Thank you, dear colleagues, ladies and gentlemen. First of all, I want to thank the University of Vienna and the Ludwig Boltzmann Institute for Fundamental and Human Rights for organizing this conference and inviting me also to give an overview on developments in international criminal prosecutions in Austria. I have already been introduced to you. I'm a judge of the Wiener Neustadt Regional Court, working since 10 years in the Federal Ministry of Justice in the Department for International Criminal Law. This department is competent, among others, for extradition, mutual legal assistance, and transfer of proceedings, transfer of prisoners, and everything connected to international cooperation in criminal law. It has also been nominated as a central authority with regard to various conventions on the level of the Council of Europe and also UN level. And so therefore also the contact point to the genocide network at Eurojust is located in this department. And myself, I have been representing Austria since 2012 in the network. So in my presentation, I firstly want to give a brief overview on the implementation of the Rome Statute, then on the structure of prosecution service in Austria, and then I will end with an overview on cases and some remarks on what has been said by other practitioners before. So implementation of the Rome Statute. Austria implemented the Rome Statute in its criminal code, Division 25, articles 321b to 321j. These provisions correspond in their wording to Article 7 and Article 8 of the Rome Statute. The law entered into force on 1st January 2015. And for me as a practitioner, this is one of the most important things to always look when the law has entered into force. So that is also, we are often criticized for not prosecuting international core crimes. We do, but we have to apply other law on acts that have been committed before 2015. So I also want to draw the attention of an interesting provision for a practitioner, which is Article 3 of the implementing law. And this provision states that acts that have taken place before the implementing law entered into force and that were not prescribed at that time, and their prescription is not already excluded due to other circumstances, do not prescribe if they would constitute an offense under Division 25. So if you're a prosecutor, and you also have to check if the offense which has been committed before 1st January 2015 would have committed an offense under Division 25, because it could be that it is not prescribed. This, for me as a practitioner, is one of the most important provisions. And you would also, if you write your indictment, state something with regard to this provision. Application of Austrian law. Austrian law foresees in Article 64 that the applicability of Austrian law for offenses in a foreign country that are punishable irrespective of the laws and the place where they occurred, also for offenses under Division 25, if the perpetrator or the victim is an Austrian national, the offense has infringed on other Austrian interests, or the perpetrator was, at the time of the offense, a foreign national who either had his or her place of habitual residence in Austria, or who is present in Austria and cannot be extradited. So this is a huge difference to Germany. As my German colleague told us on the first day of this conference, Germany has implemented the principle of universality, and they don't need any link to Germany according to their law. In Austria, it's different. You need perpetrator or victim as an Austrian national, Austrian interests, or a perpetrator who has certain ties to Austria. Having said this, I will come to the competence. We do not have any specialized prosecution service in Austria. We have 16 prosecution offices and one specialized prosecution service for economic crimes and corruption. And so also offenses under Division 25 fall within the general competence. And this prosecution office is competent where the suspect has his residence or had his last residence. And additionally, if this cannot be stated, the prosecution authority is competent, which first becomes aware of a criminal offense under domestic jurisdiction. And this prosecution authority has to lead the investigation until the jurisdiction of another prosecution authority can be established. Prosecution authorities in Austria are organized hierarchically, and on top of them is the Ministry of Justice. There are currently ongoing discussions to establish an independent federal prosecutor instead of the Minister of Justice, also as a head of prosecution authorities. The current situation is that within the Ministry of Justice, there are two units supervising prosecution authorities, and these prosecutors have the duty to report certain cases. So also all cases under the 25th Division and also terrorism cases have to be reported to the Ministry of Justice, who gives an who supervises them and ensures in a certain way that the law and the interpretation of the law does not differ from region to region. So having said that, in a certain sense, we have a specialization on the level of the Ministry of Justice. I would also like to mention that in our system, people who work at the ministry in these units are normally prosecutors and judges. So we have practitioners there who also dealt with cases as practitioners at courts or prosecutors before. After this very brief and general overview on the legal basis, I would like to come to share some thoughts on cases. I would firstly like to point out that we are talking about the investigation phase, which is not open to public. And so for this reason, I cannot share like details of cases. I can talk about challenges that have been occurred often in these type of proceedings. First of all, statistics. I was asked to present some statistics, and here are new cases in 2021, pending cases. So there are 4 cases of genocide, 1 case of crimes against humanity, 23 cases according to Article 321H, failure to report an offense under Division 25. 1 case regarding Article 321K, crime of aggression. There has not been a conviction so far. And these numbers are mentioned were the new cases in 2021. According to the statistics, there's 1 case of torture, 1 case of genocide, 1 case of crimes against humanity, and 1 war crimes case from former years still ongoing. Indictments. I'm proud to say that there has been an indictment this year. It is the case of an Austrian national who traveled to Eastern Ukraine to join a military brigade, which was fighting there in the conflict between the Ukrainian army and Russian separatists. And during the time he spent there with this brigade, he is suspected of having taken part in actions what the public prosecutor considers to be punishable under Article 321B, para 3(1), inflicting severe pain to a person protected under international humanitarian law. The indictment has been brought to court recently and has been already served to the suspect, who has now the right to object the indictment or to accept it. In the latter case, the indictment would enter into force, and then the court would have to set the date for the proceedings. But so far, when the indictment has been served, and this period of 14 days for the objection is still ongoing. So this is our first indictment on in international crimes. Some general remarks on some issues that have been discussed during the conference, the so-called Syrian cases. As I said, initially, the 25th Division of the Criminal Code entered into force on 1st January 2015. And a lot of cases concerning Syria are prosecuted under Austrian terrorism law because the acts were committed before. We have a legal definition of a terrorist organization. It is wide, and also the participation in a terrorist organization covers a lot of acts that have been committed in Syria. I give you some examples. The German colleague mentioned the so-called jihad brides, meaning young females traveling to Syria in order to marry ISIS members, or also even before stating their will to travel to Syria. This is prosecuted in Austria under terrorism law as a participation in a terrorist organization. Another group of cases is sharing and sending propaganda videos or photos, or in order to recruit new members. Also, this is punishable under a terrorist organization and prosecuted. Then we also have the cases, I just switch here. Yes, to promise to join an organization as a fighter in the future. So you don't promise to be on a certain place on a concrete date. You just promise to join the organization as a fighter in the future. The so-called sleeper is also participating in terrorist organization. Just to mention some brief examples of case law. Concerning evidence, my colleague from Germany also mentioned that you normally don't have the evidence present in your territory because the crime is committed abroad from different people, from different nations. So for these circumstances, you always are faced with mutual legal assistance, and you have to go to other jurisdictions, you have to cooperate, you have also to exchange a lot of information on police level. And this can be really, really tricky because, example from practitioners, you know that the video exists, for example, which is in possession of another state or other authority. They are prosecuting their own nationals. And you come to the point that you need this video to prove if your suspect also has taken part in some of the alleged facts. So the problem could be that for tactical reasons, the other jurisdiction is not able to share it at the moment. So you can do nothing. You have your proceedings stopped for factual grounds. Maybe that they respond, maybe not, or maybe at a later date. And these are really a difficult situation for practitioners who are, who should work very fast. And yes, international crimes are really have a different nature, also on the level of evidence as domestic crimes. Electronic evidence. What we also discussed during the Genocide Network meetings, what is not only a problem for Austrian prosecution, Austrian prosecutors are faced with, is storage and removal by internet providers. So often videos for evidence for us is removed by internet providers because of the violent content, and is not stored. And so it is really important once a video is found that it is stored somewhere and analyzed. And so to ensure this, there is a project at Europol level, which is called APCIC, the Analysis Project Core International Crimes, where states can share information like video or everything they want to share from criminal proceedings. And then Europol has the technical and personal ability to do to cross checks, to sort it and to store it, because it's electronic evidence can be a huge amount also of can take a huge amount of place and storage for a prosecution service. And it should also be archived in a certain way. You should there should be a system where you can put a keyword like a location or a name in order to establish if there is any link to another jurisdiction where maybe a suspect or another victim of the same offense is located. Witnesses. Another point witnesses. Witnesses, because of their other or different cultural background, have a completely other view on police and prosecutor. So sometimes there's a lack of trust or also a certain fear to testify, which for us is something new, because normally in Europe you don't have. If I go to a police officer or also to a prosecutor, I don't have fear to say something that occurred to me. And this is we are really glad in Austria that we have a lot of measures regarding witness protection in place. For example, witnesses have the possibility to testify anonymous, to be represented, to be accompanied by a person of trust. They can also be, during the investigation phase, questioned adversarial via video recording, and this video recording could then be presented during the main trial. Only to give some few examples. Another point that has been raised in the discussion was the cumulative prosecution of terrorism and international crimes. So this is an issue that has been discussed also in the Genocide Network meeting, and I can be very brief on that. It has been no case so far, but legally it would be possible under Austrian law. Absolutely no problem. Last point I want to make is training and cooperation. With a view to the nature of the crimes, their internationality, and also the cooperation issue that you have if you have such a case on your desk as a prosecutor, it is really key to be trained, focused on crimes and also on international cooperation and the different mechanisms. And therefore, I'm also really glad that the Ludwig Boltzmann Institute and the Ministry of Justice and the Genocide Network meeting organized a workshop on 13th of October for practitioners. Just give some few words on that. For prosecutors, police officials, officials from the Federal Agency for Asylum and Immigration, and also for judges. There were invited some colleagues from other EU member states, Germany, Netherlands, and also representative from the Genocide Network meeting, as well as also a colleague from the Vienna Prosecution Service, gave presentations on cases and challenges they faced in prosecuting, and had a real interesting discussion and very practical discussion with their peers. And what I can say, what I also discussed already with Ludwig Boltzmann Institute and also with my own office, is that we will not stop here. I think it's key to have a training and to have this sort of exchange of views also with a university in order to ensure knowledge sharing and also the knowledge sharing, and also I think an insight in how prosecution and with which challenges prosecutors are faced. So it could be a real good exchange of views, and both sides could benefit very much. So to open, I want to thank the organizers. I'm really glad we have been in contact since I think 2018 already, and I'm glad that this conference is organized here in Vienna and that we meet in person. And yes, I'm looking forward to further conferences or workshops like that. Thank you.